Imagine you're a kid in high school and you have just been cast as the lead actor or actress in Romeo and Juliet for Paramount Pictures. You're 15, you're 16, and you are going to film in Italy. You're going to work for a famous director. There will be love scenes, and let's say you get to the love scene and the director has promised you will not have to perform in the nude, you will have clothing on, you will be protected. And you get there and there are tons of people around, and the director comes to you and says, you have to do this. The two of you have to be in the nude or else the film will fail. And you will never work in this town. You will never work in Hollywood again if you don't do this. Imagine being a child and being told this. What would you do? You would probably do what you've been told and you comply. I have been an attorney in Hollywood for 16 years, and I negotiate nudity writers for actors and actresses who are adults. They have attorneys who are there to protect them with a nudity writer. We have intimacy coordinators now who act as a go-between or a mediator between the actor and the director. These kids didn't have that. Leonard Whiting and Olivia Hussey were not protected. I don't know if their parents were there. And now, 50 years later, because of a law that told the statute of limitations against sexual abuse or sexual violence against children, they can now finally bring their case against Paramount. I think they would have brought it against the director, but the director passed away. And I would say, good for them. In 2019, Governor Newsom signed into law AB 218 that told the statute of limitations for children who are victims of sexual abuse or sexual violence to be able to bring forward claims against their abusers or those who are either complicit or allowed the abuse to happen, which I think would be the argument here against Paramount Pictures. That law, AB 218, expired on December 31st, 2020, which was just a few days ago, and a slew of lawsuits came out of the woodworks. There have been two famous lawsuits against Steven Tyler and Warren Beatty, as well as against the Catholic Church and the Boy Scouts, as well as many other lawsuits that will probably come out in the news in the very near future. I will cover the Steven Tyler lawsuit separately because that has a long history to it. So as a Hollywood attorney, I have worked in Hollywood for 16 years at companies like Disney, Skydance, and BuzzFeed, as well as some big law firms. The hardest agreements that I have to negotiate are the actor agreements. The actor agreements usually have the most provisions. I usually have to negotiate many different parts of it, including their perks. I always joke that I am an overqualified travel agent. I often have to cover a nudity writer for actors or actresses to protect them during nude scenes. I cover this in my short video about Ana de Armas starring as Marilyn Monroe in Netflix's NC-17 film Blonde. So we are lucky now, thanks to HBO and shows like Euphoria, to have intimacy coordinators. The intimacy coordinator basically functions as a mediator or go-between the actor and the director. When I say actor, I mean actor and actresses. And, women are very sensitive to doing nude scenes because typically they feel very exposed. So the intimacy coordinator is there to protect them. So more and more TV shows and movies have intimacy coordinators. I just worked on a film that filmed in Boston, and it had an intimacy coordinator, which I'm so grateful for because there were several nude scenes and it was very complicated. And they're there to protect the actors, because imagine you're on set and there's a bunch of people around, probably 15, because it usually has to be a closed set when you're doing a nude scene, and you're feeling uncomfortable and you want to tell the director that you're not comfortable with his direction. I'm going to say him because most directors are men, which is something I have an issue with, which I will cover in many future videos. But let's say the director says, I need you to, show more body parts, or I need you to show your breasts, or I need you to show your butt. And the actor or the actress feels uncomfortable saying no to them. So the intimacy coordinator could be there to say no, or, she will typically, it's usually a female, she will be there with her gear to kind of help cover up the actors or actresses to make sure that they feel comfortable. They work very closely with the costume department to make sure that body parts are covered up. But imagine when you're a child, right? Especially in the 60s when there were no intimacy coordinators, I bet you there were no nudity writers, to be able to say, I'm not comfortable with this. I think through interviews through the years, Olivia has said that the scenes were fine, but I think she was just being a professional. They have clearly now come out and stated that they were not comfortable with these scenes. There was no informed consent, right? Because children can't give informed consent. Now, I believe Paramount, who has not released a statement on this lawsuit, will try to have a defense that they have signed consent from the parents of Whiting and Hussey. It's very possible the consent itself says that no nude body parts would be shown, and the director lied to the actors. Since the lawsuit have been filed, there have been experts coming out giving their opinions. So Anne Henry is the co-founder of Biz Parents with a Z, which advocates for child actors. And she states that no professional actor would touch this with a 10-foot pole, this meaning doing a love scene with underage actors. No professional actor would touch it either. I don't think anyone would put their kid in a skin-colored bodysuit today. Henry says that studios would avoid controversy in such situations by hiring an 18-year-old actor who simply looks younger. I know that happens a lot, right? So what you have to understand is I'm a strong proponent of nudity writers, of intimacy coordinators, because I believe actors and actresses need the protection and an advocate for them. So when I negotiate a nudity writer, it would typically has many provisions. It would state what body parts the actor is comfortable showing, the fact that it has to be closed set. Most people cannot have their cell phones on them. When the scenes are being edited, it will be a limited amount of people who can be there. When there used to be negative films, they would be locked up each night. Things like that would be in place to protect the actors. And even if there is a nudity writer, what people have to understand is the actor or the actress can always change their mind on set, right? And say, I'm not comfortable with this.
No.
No.
No!
No. No.
And the intimacy coordinator would be there to protect them and advocate for them. But Olivia and Leonard didn't have an advocate like this. In the 60s, there were no such things as nudity writers or intimacy coordinators. And I'm doing a video focusing on intimacy coordinators because I think the work that they're doing is so important and so fascinating. And it really does protect a lot of actors, and especially female actresses. If you have found this video to be of value and if you learned something, please consider subscribing because it really does help my new channel. So the lawsuit by Whiting and Hussey states that they're suing Paramount Pictures for sexual harassment, negligence, intentional tort, fraud, appropriation of name and likeness, intentional infliction of emotional distress, unfair business practices, and child sexual abuse. Basically, the director assured them that there would be no nudity filmed or exhibited and that they would be wearing flesh-colored undergarments during the bedroom and love scene. But Whiting and Hussey are claiming that they suffered physical pain, severe mental anguish, and emotional distress, as well as a lifetime loss of earnings. They state that because of them showing their nude body parts as children, they really couldn't get any more work in the future. And it does seem like there might be some truth to it because they didn't seem to act in any other films after Romeo and Juliet. So what they're looking for is they are seeking general, compensatory, and punitive economic and non-economic damages believed to be in excess of $500 million. Paramount authorized, condoned, and or ratified the unlawful conduct by repackaging what is essentially porn and the evidence of a crime and then reselling that poisonous product for profit over the objections of Mr. Whiting and Miss Hussey since 1968, the lawsuit alleges. says, the knowing and repeated use of sexual images of minor children is the worst behavior in our society and must be eradicated. You know, AB 218 was written kind of vaguely and broad to capture instances like this, right? I think the intent of 218 was really to protect children who are victims of sexual assault and sexual violence, which isn't exactly the case here. They're arguing that the film constitutes child porn, so it might fall under the statute's broad definition, especially if they can prove that the director tricked them into performing nude. Attorney Jeff Anderson says the answer is yes, they have a case here. His firm recently filed the lawsuit against Steven Tyler and Warren Beatty. He states that nude images of children that do not meet the legal definition of porn or pornography can still live on the internet forever and follow actors into adulthood. Those harms have not always been fully appreciated, says Henry, who believes the lawsuit will make kids safer on set. I really appreciate that they came together with this allegation, Henry says. Whether the lawsuit has any merit or not, we appreciate the conversation. For the good of society, the conversation is what matters here. So I believe this is something that Paramount will have to handle. Most likely, they will settle something with Whiting and Hussey to take care of them and to make them whole again, because they do have some legitimate arguments here. I have been a strong advocate of women's rights, working in a women's shelter for over 10 years, helping women get restraining orders and leave their abusers. And I recently made a video about the Balenciaga ad campaigns that featured children and a Supreme Court case about child porn. And it's just terrible and heartbreaking when children are exploited and not protected, like the actors here for Romeo and Juliet and like the children in the Balenciaga ad campaigns. If you didn't catch that, make sure to catch it here. This is Tyler, the Hollywood attorney. Remember, we were born perfect and we just forgot. I'll see you guys soon. Okay, bye.